did promise you that this week.
It does not say that a person charged with the offense of murder gets bail. It says that you can make an application for bail. The judicial officer considers all of the factors set out in the legislation, in the Bail Act. And then the then government, PM government in 2024, would have brought an amendment to raise the threshold to suggest that if you have to give bail to someone charged with the offense of murder, they must be able to demonstrate exceptional circumstances. Very simple matter that we're dealing with. In fact, we thought it was very simple. But, Mr. Speaker, they came into the Parliament in 2024, and a simple matter like that, they messed it up. They messed it up. And that is why today they have left the judicial officers of the judiciary sitting in the criminal jurisdiction confused. That now the Court of Appeal has to go and figure out what they were trying to do with their bad drafting. We warned them. We warned them and told them that it was wrong. You didn't listen. And today, a UNC government now has to come and clean up your mess.
But we will fix it, don't worry.
And we will fix it. And if I am to summarize what my friend from Laventil West and my colleague from Port of Spain South would have said, they said the provisions that we're including in this bill of 2026, makes bail onerous. It makes it difficult that we are denying people bail. That's basically what they're saying. But, Mr. Speaker, I want to take you back when Achille Charles was decided. There's a Guardian article dated the 1st of November 2023, and it's titled, Scotland, Time to Revisit Bail for Murder Law. And this is what the article says, and I'm quoting. With accused murderers now able to access bail from court, Port of Spain South MP Keith Scotland says TNT needs to revisit legislation to once again deny them from being released from remand. You hear? So,
What date was that? What date
so in 2023,
What date was that?
in 2023, you're telling the country, listen, don't give them bail. And in 2026, you now come to tell us, will we make it too hard to give them bail? You see what you call hypocrisy, Mr. Speaker? If that is not hypocrisy, I don't know what is. And then their former Prime Minister, there's a Newsday article by Yvonne Webb, dated the 14th of February 2021, Valentine's Day. PM, no bail for murder must remain the law. No bail for murder must remain the law.
Valentine's Day.
Our position at all material times, Mr. Speaker, was not to say to release people charged with murder, We never said that, We said that there's a constitutional right that they can apply for bail and let the court decide yes or no based on the factors of the case on a case-by-case basis. Simple. We are fixing it now. We are fixing it now. But I'm troubled by the submissions made by my bright friend from Laventil West. Because my friend said, and he reads the legislation without context, and Mr. Speaker, you are a man of context.
Too much.
And what he said is that all offenses will be subject to a bail source hearing. Now, the literal interpretation of what we have in the bill says that. But if you read further, Mr. Speaker, it then qualifies it to say that a court shall conduct a bail source hearing in relation to all offenses, we're not disputing that. In attempting to post to secure bail, the accused or the surety presents A, cash in the sum of $30,000 or more, or B, a certified copy of a deed. Now, my friend said that, listen, if you get arrested for resisting arrest and you go and apply for bail and so on, Mr. Speaker, any criminal practitioner will tell you, you just get own bail for that. You just get own bail. You know what is own bail? When the court grant bail, you go and sign your own bail. So it had nothing about 30,000 and people remaining in jail or remand for 10 days, 15 days, 20 days. They, Mr. Speaker, are taking the legislation out of context from what the actual practice is in the jurisdiction of the criminal courts. It is a simple matter. Now, as the offenses get more serious, as the risk of the person fleeing becomes more possible, as the person may be a repeat offender and so on, of course the court can impose a greater deal of restrictions when it comes to bail. Sometimes, Mr. Speaker, the court has a host of options, a menu to determine the conditions of bail. You could have reporting, you could have curfews and so on. You could even have electronic monitoring as a form of bail, as a condition of bail. So, Mr. Speaker, when my friends opposite come to fearmonger and say all offenses, if you get resisting arrest, all of those things, Mr. Speaker, that you have to go to this bail source hearing, that is absolute rubbish. I don't want to say that, I get in trouble here. Yes. That is nonsensical. It's nonsensical. And that is why, Mr. Speaker, I am troubled by the submissions being offered by my friends opposite. Because they have not, Mr. Speaker, placed the legislation that we are proposing within the context of how the courts actually operate. They're not doing that. They're not doing that. They're fearmongering. They are fearmongering. You remember when we were passing the home invasion bill, how they were fearmongering the country? Yes. You remember that, Mr. Speaker? And they are doing it again and again and again. We want to instill fear in the hearts of the criminals. That is what we want to do. Help us put the fear in the hearts of the criminals. Help us do that. Do not allow the criminals to run free, because this government is serious about crime fighting. That is why you could never do it, and we could have reduced crime to the lowest ever in 10 years. Murders down by 42%. 42%. That is why we could have done that. That is why we could pass good law. That is why we could govern the country, and that is why we have a prime minister who is in charge. That is why we could do that, Mr. Speaker. Then I heard Port of Spain South saying, well, it's so difficult to go and do a land search on a property. There's something in the Ministry of Legal Affairs, Land and Legal Affairs, called PBRS. You could do a land search online now, Mr. Speaker. You could do it in less than 2 hours, 3 hours. All the deeds are scanned. Most of the deeds are scanned on the system. And if the deed is not there, you can demand that the scan be made up and we can upload it for you. So again, Mr. Speaker, the member is engaged in fearmongering. They need to stop it. They need to stop it. But they will never stop, you know. That is why they will remain on that side. Imagine, Mr. Speaker, we have to go for rating, re-rating, also an assessment in March for FATF. This particular bill before us is one of the pieces of that puzzle in terms of getting us out of the blacklist that they put us on. That they put us on. They put us on that list. We are trying the best that we can do to get off the list, so that we can become more competitive internationally, because you know Trinidad and Tobago is open for business. We have been talking to international partners. We want to ensure that we have a rating of compliant so we can do business worldwide, Mr. Speaker, but yet they are fighting us down on these things. For once in your life, be patriotic. Put away the Balize tie. Put it away. Put away the Balize tie. Then I heard my friend talk about, from Laventil West, talk about the Justice Gobin decision in terms of that the vetting policy that the judiciary had instituted was unconstitutional. Now, I want to refer my friend to a later judgment by Justice Henderson, and this judgment was delivered on the 16th of March, 2023, and my friend can go to paragraph 20, 17 phase, and then we go to the others. And I want to quote Mr. Speaker. Justice Henderson is saying this in terms of commenting on the judgment of Justice Gobin. He said, in my view, the basis of the finding that the judiciary's vetting process is unconstitutional appears to be found in paragraph 11 of this decision, where my learned sister, when dealing with the affidavit of Ms. Birbal and her use of the term security while describing the surety approval process, said of this that the evidence confirms a fundamental legal error, one which confuses and conflates the condition that may be imposed on a surety to be approved by Section 16.3 and the provisions of security by a defendant under 12.4. It is my respectful view this conclusion is misconceived. Notwithstanding her use of the term security, it remains clear that the entire investigative process was directed to assuring that a potential surety would be in a position to meet his obligation should the accused abscond. Mr. Speaker, my friend told me he passed all of his exams. He said he bright. But he didn't read this judgment. He didn't read this. And you had your time? He can't, and he's in the same jurisdiction. So if you can use Justice Gobin's dicta, I could use Justice Henderson's dicta.
It's basic.
It's simple. It's simple. And if all they wanted to fix it, all they had 10 years and all they did nothing. I go on to paragraph 20 and 21 because I feel, Mr. Speaker, I have an obligation to educate my friend from Laventil West. At paragraph 20, the court said that the court must be satisfied that the property intended to be used by the surety is capable of being utilized in that manner. Anything less would render the requirement for a surety entering into the recognizance ineffectual. This court agrees that there are sanctions which deal with the issues of forged deeds, fraud, giving false statutory declarations, and professional bailers. However, it is unlikely that persons seeking to perpetuate fraud or professional bailers will come to the knowledge of the judicial officer without these checks being made as outlined. And what we're doing, Mr. Speaker, is just adding a layer here now to ensure that the property being used or the money being used is clean money and not criminal money. That is what we're doing. That is why you're asking the court to inquire in terms of the source of the funds and to make sure it is clean property that's being used. So what is your objection with asking a judicial officer to just examine the security that is being used is lawful? What's wrong with that?
One wonders.
Why? Why is that an issue? Why is that an issue? Because I think when you look at the legislation, that is the simple point. Just ensuring that the security that the accused person put up is in fact clean. I don't think it's much more complicated than that. It's a very simple issue. But my friend goes into all of these complex constitutional arguments that I feel they don't even understand, because this is a real simple matter that we're dealing with here. It's a simple proportional matter that we're dealing with here to fight white-collar crime. You see, if somebody decides to use a building, maybe 5 stories tall, red in color, bought by Caraffles, I don't know if that might be a clean property. I don't know. It might be situated on Tranquility Street. I don't know. I don't know. But that may or may not be a clean property. And you will be vexed with a judicial officer if they go and examine that. That is the kind of things that we want to capture in this law. What if, Mr. Speaker, a lawyer receives $6 million in briefs? I don't know. Maybe the lawyer was hired by the Ministry of Finance at one point in time. Maybe the lawyer was hired by the AG's office at one point in time, collected $6 million in legal fees until they happen to sit in the next house of this parliament. We want to ensure if he decides to become a cash bailer, that money is clean. What's wrong with that? What if another one of them was a consultant for the government, the previous government, receiving $250,000 in consultancies, and now sits in an independent position in the next place? What's wrong with that? What if our next one was appointed to our board, getting a stipend of $9,000 per month, and also got state briefs for about $250,000, but now say they're independent? Mr. Speaker, I want to know if that money clean. The court, what is wrong if the court examines that? Nothing is wrong with that. You must understand whether or not the court is dealing with legitimate property. Because, Mr. Speaker, if you are going into this particular matter and assuming the person who takes out the bail puts up a property that doesn't exist, the property is with respect to an offense that can fall within the Proceeds of Crime Act or something, the person absconds, this property is used as security, and the state now cannot recover. What happens? The state loses. Bandit gone. You understand? So what we have to do, Mr. Speaker, is we have to ensure that we give law enforcement the power. We have to ensure that we can give the judiciary the powers to inquire, but we have to also ensure on our end that we meet our international obligations. That's what we're trying to do here. Had it not been for what you all call the UNC lawyers, there will never have been a right to apply for bail for murder. Exactly. It was Mr. Ramlogan, through the Achille Charles, that brought that case. And Mr. Speaker, a case that you might be very familiar with, Achille Charles was not the first time in the jurisdiction that this conversation of bail for murder came up. There's a decision called Krishndat Sinanan against the state, number 1. It's a West Indian report judgment, reported in the West Indian report. And in that case, Justice Sharma would have outlined in his decision, Mr. Speaker, that he held in his conclusion at page 382, and the citation is 1992 44 West Indian report at page 382, he concluded, and he quotes, "He would therefore hold in the case of murder, treason, and piracy and other offenses in which the sentence is either life or imprisonment or death, judges of the Supreme Court have the power to grant bail." But it was a dissenting judgment nonetheless. But it's not the first time that conversation was before the courts in our jurisdiction. So that is something, Mr. Speaker, that we have grappled with. We understand where we are in terms of this. Mr. Speaker, the Minister of Defense already signaled with respect to our position on the special majority requirement of this bill that we don't believe that this bill requires a special majority. I think we have reached, or we meet the thresholds and the standards as set out in Surat and in Suraj. And I think we are within the constitutional limits, Mr. Speaker, to pass this bill without the required special majority. Because I don't know, Mr. Speaker, people who collect $6 million in brief might vote. I don't know. I move on, Mr. Speaker. Mr. Speaker, Mr. Speaker, and on that point of the constitutionality, Mr. Speaker, you know, they will go on a political platform very soon, and they will jump up and say, we are autocratic, that we are eroding democracy, and that we are dictators, and so on. They'll go, you know, they'll go. But I want to correct that from now. Let me take front, Mr. Speaker. Because you know why? When they brought the anti-gang bill, what they did? They removed the special majority. When they brought the Interception of Communications Amendment, Mr. Speaker, what they do? They removed the special majority. The Marriage Act, they removed the special majority. The Income Tax Amendment, they removed the special majority. The Evidence Act, they removed the special majority. Procurement Act, they remove it. Gaming and Gambling Act, they remove it too, the TTRA Act, Mr. Speaker, they take out the special majority, Mr. Speaker. So, Mr. Speaker, I'm waiting for them. I'm waiting for them to go on a platform and accuse us of this because we have the data, we have the facts, and we have the records, Mr. Speaker. I have it. And if you only go further, just remember, Senator Al-Rawi words are captured on the Hansard of the Republic of Trinidad and Tobago Parliament. If you go further, but I don't think I want to go today to quote him extensively, except to say that he was the same man to stand up right in this spot and say that he could do that because of Surat and Suraj. He could say that. So, Mr. Speaker, today we have examined this bill with a constitutional lens, and we believe that we are on the right footing with respect to passing this law with a simple majority. And there's no fear, you know. Mr. Speaker, I told you I like to work with my data, my facts, and my statistics. I have some numbers from the judiciary with respect to bail. In the year 2023, San Fernando, I'm dealing with capital offenses now only, Mr. Speaker. Of 153 applications that were filed in Port of Spain for capital offenses in 2023, 26 succeeded. In San Fernando, there were 49 applications made, 19 succeeded. For capital offenses in 2023 for Tobago, 18 were charged, 5 succeeded. In terms of 2024, applications filed for Port of Spain, 89, 17 succeeded. In San Fernando, 33, 13 succeeded. In Tobago, 14 made, 2 succeeded. In the year 2025, capital offenses for bail, 37 applications filed, 5 succeeded. In San Fernando, 12 applications for bail for capital offenses filed, 2 succeeded. In Tobago, 4, 0 succeeded. So it's not a massive floodgate being open and say that everybody charged with bail coming outside. No. The judiciary has an exercise. It's something that we can't stop. The Prime Minister always relies on one of these cases, the Querati against the state, where it declared that Trinidad is declared as a sovereign democratic state, which interprets the fact of the rule of law, the separation of powers principles, Mr. Speaker, that we in this Parliament ought not to get into the denial of bail. That is the work of the judiciary. We could regulate certain things that Achille Charles told us we can do, and that is what we are doing at this point in time. We are going absolutely no further than that, Mr. Speaker. We are going no further than that. But my same friends opposite complain about the source of funds thing with cash and so on. Mr. Speaker, all we are suggesting is that when the bail crosses $30,000, 30 or more, you have to just show the source of funds. You know, if you're going First Citizens Bank to deposit about $140,000, you should have shown a source of funds. You should have, you know. You can't carry it in a brown bag. You must do that. You must show a source of funds if you're going to deposit a particular limit in a financial institution. So it's the same principle that can apply right here, Mr. Speaker. Mr. Speaker, the other thing is, with respect to a trial, they said that the court will conduct a trial for the bail source hearing. One member, I think, said a voir dire that they will conduct to determine a trial within a trial to determine whether or not we should grant this bail for the bail source hearing. Absolute nonsense, Mr. Speaker. We are going no further. All we are telling the court is to examine the means that they already have the power to do in terms of determining the sufficiency and suitability of the surety, and then you look whether the security that they're putting up is clean. It's clean. Simple, simple, simple matter that we are dealing with here, Mr. Speaker. Mr. Speaker, in terms of the other points that they made, if they made any more, yes, I heard they talk about the conditions of the judiciary and how many masters that they would have hired and so on. I want them to now explain, when they hired all of those masters and judges, how much support staff they gave to them. You know, Mr. Speaker, it had judges sitting down in this country who could not have functioned because they did not have a team to work with them. You know that? That is what they left. You know, they left all of the court buildings to rot, Mr. Speaker.
They did.
They left all of the court buildings to rot. San Fernando does not even have a high court building. Or a magistrate's court, I'm told. They have left every single building to rot. Spent millions and millions of dollars to outfit the waterfront. And when you go in a courtroom, Mr. Speaker, it looks like an office. It looks like an office, it don't look like a courtroom. That is their legacy. Our legacy is to fix the judiciary, fix those court buildings, and fix the criminal justice system. And we are starting to do that right now, Mr. Speaker. We are starting with the legislation, and pretty soon, the Minister of Justice is charged with the responsibility to take care of the court buildings according to his ministerial responsibility. Mr. Speaker, there are no more matters I wish to respond to because I don't think my friends opposite would have said anything of any substance to really convince us, except that they would like to frustrate the entire procedure. They went from not supporting to then ask us to put it in a JSC, and then they'll put us in a JSC and they'll extend the period while you have the courts confused, while you have us having to go for re-rating with respect to FATF and so on. Mr. Speaker, we are not taking their delay tactics and to frustrate us. We are not doing that. We are not doing that. The people of Trinidad and Tobago gave us a very, very, very handsome mandate, and we are about to use that, Mr. Speaker, to ensure that we govern for the safety and security of all of the citizens of Trinidad and Tobago. And I thank you very much.
Thank you very much, Mr. Speaker, and I do not intend to be long at all. I just intend to deal with some untruths that were put into the system. The member for Barataria, very untruthfully, and I'm sure he knows better, stated as a fact that it was the PNM administration that caused Trinidad and Tobago to be put on a Financial Action Task Force, FATF, blacklist. That is a colossal untruth. Colossal. Trinidad and Tobago was placed on a grey list in 2017, and this is the reason. The placement followed a poor performance in a fourth-round mutual evaluation by the Caribbean Financial Action Task Force, CFATF, in January of 2015. And Mr. Speaker, who was the government in January 2015? Them. So they failed a fourth-round mutual evaluation in January 2015, and as a result, Trinidad and Tobago was placed on a FATF grey list. And this failure of the UNC with respect to FATF was not the first time. They were previously identified in 2010 and 2012 when the UNC was in government. Now, what happened after that? What happened after they failed the FATF evaluation in January 2015? What happened? The same senatorial colleague of mine is the one that got Trinidad and Tobago removed from the grey list on February 21st, 2020, when the PNM was in power. And that is why I call it a colossal untruth. Trinidad and Tobago was not on a FATF blacklist. It was placed on a grey list because of them and was removed because of us. That is why I've joined this, because I am fed up of the untruths that come from the other side. Fed up, absolutely fed up. So this story about how you have to do this, you have to pass this legislation because we are on a FATF blacklist because of the PNM, is a colossal untruth. Colossal untruth. And I won't talk much more except to point out and to join my colleague from Port of Spain South with respect to this whole question of a Nebbia hold, which applies in the jurisdiction in the United States. And in the United States, and you see what is wrong with this bill, it removes judicial discretion. And in the United States, even though the prosecution can ask for a nebia hold, which is essentially a hold on bail while the source of funds is determined, the judge has the right to refuse the request for the nebia hold. What this government is doing is removing the discretion of the judge in these circumstances. And therefore, there is no comparison between what occurs with a nebia hold in the United States and what this bill seeks to do. And those members opposite who practice in the criminal courts, the ones who actually practice, that too, they will know that in a majority of cases, when a person requests bail, they do so with a surety. They said so themselves that cash bail is a rarity. There are all sorts of reasons for this. It's a surety, a deed. And what you are doing now is you are introducing this element that the judge has no discretion, the magistrate, whoever, the master has no discretion to grant bail. They now have to do a source of funds investigation with respect to a surety. And that affects the lowest common denominator, the poorest of the poor. Because now, the little man who is accused for an offense, now he has to wait in the remand yard, wait in the detention center, while some sort of forensic examination is done of the surety. And my friend from Laventel West made the point. How far are we going in terms to determine the legitimacy of a deed? Are you going to go 30 years back to see if when the property was acquired, it was acquired through illegitimate means? Where are you going to stop? What are the rules? What is the framework to determine the legitimacy of a deed? What about somebody who obtains title through adverse possession? Where are you going with this? You see, you all just like to talk, but you don't think things through. All you're going to do is you're going to overcrowd the remand yard. The conditions are already inhumane upside there. You're going to put more and more poor people into detention centers and the remand yard. And you know that. It's deliberate. You know what you are doing. Because if it was not deliberate, then you would do what the United States does with the same nebia hold. It is used primarily for serious crimes, for racketeering, for major white-collar fraud and so on. You would not have put a wording into this law that would allow people who present a deed for a minor crime now to be subjected to this level of forensic examination. You know what you're doing. You want to punish people. You want to put them in jail. You want them to be detained. You want them to suffer. And that is the issue. Not the old talk I just heard from members opposite. The waffling and the old talk I heard from members opposite. Deal with that. It has nothing to do with $30,000 cash. It has to do with surety. And in the preponderance of cases, a surety is used in order to secure bail. And they know that. So, members opposite, you could pass it with, of course I read it. Of course I read it. It says a court shall have a sufficiency hearing if it's cash bail for $30,000 or using a surety. Of course I read it, unlike members opposite. Of course I did. And while you're at it, fix the definition, because the definition contradicts that clause that deals with the $30,000 cash and the surety. Fix it. The definition speaks to the prosecution requesting a sufficiency hearing and the court being mandated to do it. Fix it. It's contradictory, but that's a minor point. The fact of the matter is that you are deliberately going to suffer the people at the lowest level of the income strata in Trinidad and Tobago. And that is your policy. We saw that with the zones of what I call special oppression. We saw that. That is your policy. You want to punish poor people in this country. So you could fool anybody. Use your special majority, use your simple majority, pass it anyhow you want, upside down, left, right, I don't care. Pass it. But all you're going to do is that you're going to sink deeper and deeper into the morass. And more people in this country will come to hate you. Thank you, Mr. Speaker.
Member for Toko Sangre Grande.
Mr. Speaker, back to reality. Back to reality. From what obviously is the rant of a madman. Because, Mr. Speaker, if you consider what the member for Diego Martin East just said about a Nebbia hold, Northeast, it's obvious that the member for Diego Martin East is limited, in spite of having a master's in law, is limited in terms of his knowledge of the law. Because, Mr. Speaker, he makes the point that under...
Member, I think your leader of government business.
Mr. Speaker, I think there was some miscommunication. The leader of the opposition wanted to speak, and I saw my colleague from Toko Sangre Grande get up, so I'm sure he would be willing to give way.
You're quarreling, you're not speaking.
We're giving them the opportunity, Mr. Speaker. This is not by any means an attempt to stifle the leader of the opposition, and therefore this is the opportunity we are giving way to allow the leader of the opposition to speak.
Member for Rima, the member has chosen to give way. Should you seek to avail yourself of it?
No, thank you, please.
In any event, there's a standing order. I think it is... No, if you feel that the debate is being unfairly wound up in circumstances where you're of the view that is an oppression, a suppression of the minority, you can avail yourself of the standing order. For ease of reference, it is, I think, Standing Order 52. So
Mr. Speaker,
it's a matter that entirely for you.
It does not fit into that section.
Well, I disagree. There are circumstances in these standing orders where all right, Maro, I'm simply saying the member is giving way. There are two avenues available. The member mistakenly has gotten up to wind up the debate. All right, he's giving way. If you choose not to avail yourself of that, fair enough. But there's also an avenue where if you feel that a debate is being unfairly wound up in circumstances where it may constitute an oppression of the minority, you also have the availability. You also have recourse to that particular standing order. Should you choose not to do so, it's a matter entirely for you. Am I to take it that you do not wish to avail yourself of those two opportunities?
I already said to you that in my it does not qualify based on what you have said.
We will agree to disagree on that. Member for Toko Sangre Grande.
Dear. Poor thing. Mr. Speaker, we do not wish to oppress the leader of the opposition or any member on that side. We have graciously given them the opportunity, have given way. We've given way, and now they are seeking to prey upon technical arguments to avoid the opportunity to address the people of this country.
There's no need for that vitriol. If you wish to invoke the relevance rule, I can understand that. But there's no need to diminish what you have to say by by resorting to that kind of vitriol. Remember, let's just move on with the wrapping.
Thank you. I just want to make it clear. I don't take bullying from bullies. So, Mr. Speaker, let me go quickly to what the member for Digger Martin East stated. He, in essence, stated that in the United States, the judge has a right to refuse the request for a nebular hold. In essence, he's saying the judge has a right to not accede to the request of the state for a bail source hearing. Nebula is 1966. There are federal statutes and state law statutes, the state legislatures, and the federal law has changed since that. But let me just say, the fallacy in the argument put forward by the member for Diego Martin East, Northeast, and another member, I think it's Laventille West, lies in the fact that, one, the court on its own motion can determine to having fixed bail at 30,000 and up. The court on its own motion can embark on the bail source hearing. The court, at the insistence of the prosecution, can embark on the bail source hearing. But for the member to suggest that the court has no discretion displays a woeful ignorance of the case, the Privy Council judgment in Charles Matthews. Because people with a basic understanding of the law would say that shall is always mandatory. But people who have an advanced understanding of the law and people who have read Charles Matthews would know that shall is not always mandatory, and particularly when it is directed to a court, shall can, in context, be determined to be directory, as in this case. So it is an argument that you can make, but an argument that you would have to deal with, and an argument which, in essence, would be easily disposed of by reference to the Privy Council judgment in Charles Matthews. But what is quite clear about the legislation and the bail source hearing is this, and two things. One, if the judge or magistrate is of the view that in the circumstances of the case, having regard to factors in 6.2 of the Bail Act, if the court finds it necessary to impose a bail of 30,000 and up, it is the court itself, by fixing bail in that amount, it is the court itself which triggers the legislation to go and embark upon a bail source hearing, either on its own motion or at the insistence of the prosecutor. What's wrong with that? What is so wrong with that? And it is quite clear again that this obviously is directory. Now, there's not much to reply to because my learned friend from Barataria San Juan, in his contribution, said most of what I wish to say. And it made me reflect on what Lady Justice Singh dealt with in her application, and when she made reference to the proceedings in the committee stage in 2024 legislation, when one man from Sawa Barataria was able to demolish 8 lawyers from the PNM. One man. Yeah, one man. So I want to pay homage to my friend Saddam Hussein, member for Barataria San Juan, for, in essence, making my work very easy in wrapping up. But I can't get away. I see he's run off, the member for Laventille West. Yeah, he's gone. And you see, I wanted to deal with the member for Laventille West, and without any kind of, and I'll be very kind to him because, in essence, he seems well-intentioned. I think he means well, but he clearly lacks the legal acumen, and he clearly lacks the experience. And two things struck me in his contribution, which I have to address now. The first thing he said is that we should commit this bill to a joint select committee of Parliament, and when we commit it to a joint select committee of the House, that we should invite the judiciary. That is the most bizarre proposition of law I have ever heard. Invite a member of the judiciary to be part and to take part in the deliberations of the Joint Select Committee. Invite them to do what? For God's sake, man. I commit that on Monday morning, because it's late Friday, on Monday morning I'm going to go to Book Specialist and I'm going to buy Tom Bingham's Rule of Law for my friend from Laventille West. Because it is quite clear, Bingham quite clear stated the reason why judges can't take part in joint select committees and so on. To do what? How does it look that a judge or a member of the judiciary, magistrate, takes part in the proceedings, advises the Parliament on the proceedings, and then has to sit in judgment of what took place in those proceedings? Sorry. That has to be... Well, yes, it's overzealous. That's because I realized earlier o'clock that my learned friend from Laventille West had nothing to say. What he did, and it reminds me of a few friends I have, that sometimes you study for a particular topic, it didn't come, but you have some knowledge of the topic, and you write everything you know about that topic. But I do not, and I say all of that with the utmost seriousness, but with absolutely no malice whatsoever. None whatsoever. Because my friend is a young man, recently called to the bar, and I don't want to put him down. He made a really brave effort. And it really takes a lot of gumption to stand up for 45 minutes and say nothing. I think he's learned from Senator Faris Al-Rawi. But he made another very interesting, he raised another rather interesting point and said, in essence, I wasn't here. I went to the Oval Office, and my friend Member Mohit made some notes and told me that the member for Laventille West said that maybe we should invite the Law Association and seek their opinion. What? To do what? Mr. Foreman, sorry, not Mr. Foreman, members of the jury, Mr. Speaker. Mr. Speaker. The Law Association was recently called upon to give an opinion in the Zones of Special Operations Bill. And it became quite clear that they lacked the expertise to proffer any opinion. It became quite clear that there was no one of note on the Law Association with any kind of legal acumen to proffer any suggestion of substance. And I used just one example, but there were several. I used just one example. And it can arise right in this bill, and I'll show you. They, the Law Association, said that 50,000 was too draconian a fine. They completely ignored, and if they knew it and ignored it, then it questions their integrity. But they must have known, any lawyer worth his salt would know, that when legislation makes reference to a penal provision and says that the fine is X or the term of imprisonment is X, it is basic common sense and basic law that that is the statutory maximum. It is basic common sense that even first-year law students know that Parliament cannot tell a court what sentence to pass. So that even if at first glance something looks draconian, the court can go all the way down. It can impose a bond, it can impose a fine, it can reprimand and discharge, tell you go home, go your way. And the Law Association either forgot to put that. No, it's not that they forgot, because they averted their mind to it and demonstrated quite clearly either they did not know or, something has to be wrong with that, because there's a Court of Appeal judgment in Francis and Hines. I think Mr. Speaker, you are familiar with it. That makes that point very clear. So how could the Law Association be proffering opinions and not know the most seminal cases on a topic upon which they purport to opine? So I raised that so that my friend from Laventille West, who has run away, and I hope he looks at the debate tonight, that he would never make the mistake of trying to invite or impose the Law Association on this House. At present, their opinions mean very little. Let me go to my friend from Port of Spain South, who, again, why are you telling me about Masuka Man jockey shows? What interest you have in that? Let me deal with my friend.
We have to talk about people.
Let me. So quiet yourself.
Right through.
Quiet yourself.
Right through.
Quiet yourself.
Be obsessed.
My learned friend from Port of Spain South, again, had not much to say. My learned friend from Port of Spain South, again, like Senator Faris Al-Rawi in the Zoso debate, decided he is going to talk about separation of powers and that this bill offends the separation of powers and therefore some sort of majority or something is needed. That it's not just a 3/5, that it might be more. My learned friend must not have read paragraph 89 of Achille Charles. Paragraph 89 of Achille Charles states quite clearly, the separation of powers is not a freestanding, legally enforceable principle that exists independently of and above a constitution. It's simply an arrangement. So even if you think, and think mistakenly, that there might be a breach, let me see you go and try to argue it, because you'll be wasting time. But what was even more disappointing, and I have to go here, because there was a big song and dance about the court having the power to inquire into where you got $30,000 from. Every lawyer knows that if you are driving in your car and you have $20,000 and a shilling or 5 cents, that the police can stop you because that's gazetted and ask you, boss man, where you get that from? You're not supposed to have that kind of money on you, in your car, in your house, because if they find you with it, it triggers a certain type of procedure under the Proceeds of Crime Act, where there's an investigation and you have to explain where you get it from. And my learned friend from Port of Spain South should know, because I read in the papers quite recently that something was found by him and he didn't disclose that. Something much more than 20,000. So don't come here and try to ramage and say we're going after poor people. We're going after everybody. We're going after everybody. And I'm sorry I had to go there, but I went there because you did it first. You did it first. So anyway, let me see what else my brother... Well, I don't need to go into the conflicting decisions between the judgment of Gobin J and the judgment of Henderson J. There's another judgment which sides with Henderson J. It's a judgment by my good friend Trevor Jones. But the bulk of the contribution from my friend from Laventille West touched upon the types of offenses that could attract a bail source hearing. Now, and he made the point that sometimes you mightn't be able to raise the bail, so then you stay inside. My friend, again, must not have read the Bail Act, must not have read any book on sentencing, because two things become quite clear. The courts will only impose 30,000 and above for the most serious of offenses. Not, as my friend said, resisting arrest. I've never seen resisting arrest attract 30,000. Obscene language, I've never seen that attract 30,000. All of the offenses he referred to do not attract that. You are giving your own bond. And what the courts take into account is this: paramount, the method for treating with the offense and the offender. And the court takes into account that if I keep you in custody and you are found not guilty, then you would have, in essence, been deprived of your liberty, which is a punishment, and you would have been deprived of that liberty before trial. So the court would take all these factors into account and say, you know, even if I find him guilty, I'm not going to impose a custodial sentence. And in those circumstances, the court will say, own bail, that's routine. But I can understand my learned friend from Laventille West not knowing that, because he's green in the practice. Again, I said he's well-meaning, well-intentioned, so I wouldn't beat him about the body for that. And there's not much more from him. Well, he raised a point about if you purchased the property 30 years ago, how are you going to prove that it's not from ill-gotten gain? That proposition need only be stated to be rejected. Because if you own property from 30 years ago, you have a deed suggesting that you purchased it 30 years ago, there is nothing that would raise the magistrate or the judge's suspicion to say, well, this has to be the proceeds of crime. That's basic common sense. So again, my learned friend from Laventille West said nothing. In fact, I shouldn't even have addressed it. I simply raised it to educate him. Let's deal with my friend. I see he's looking at me like he want to beat me. My friend from Port of Spain South. And he raised the issue about the purpose of bail and the purpose of a surety. We all know that. But you see, what this bill is targeting, as my friend from San Juan Barataria alluded to moments ago, is this. When someone takes bail, that person is pledging to the court that I am giving an undertaking, I'm giving an assurance, I am sure that I can ensure the attendance of the accused. I'm willing to bet money on that, and you hold on to my money or my deed. That's the point. But you see, when the money is from ill-gotten gain, and the leader of the 6, or the 7, or the 8, when they make that easy money, they can pledge that and afford to lose that because it wasn't earned, as the Bible says, by the sweat of thy brow. And that is what the legislation is getting at. People who vouch for you would risk their hard-earned property to say, I'm so sure about you, and I'm sure that you value me so much that you would turn up to trial so that I do not lose my property. That's what bail is. That I know that you value me so much that you would make me lose my property so that I could put up my property. Yeah, trust. But when is 30,000 cash bail? There is not even a brick of cocaine. We gonna get that back. Man, take your bail, jump your bail, go your way. I see they laughing. Papa, yourself, before I bought and going Serrano Road, and I discovered recently, whilst I was debating in the Senate, the Zoso, at that precise point, a friend of mine, his son was murdered right there. And when I went away, the body fall down, I see a poster of Kareem Marcel. But you know up in how he can reach? Poor thing. I could go where I want. Come, San Fernando. I could go where I want. No, well, he started it.
Yeah, no, but besides that, that's besides the point. Whoever starts it, that's besides the point. This is not a schoolyard.
Yeah. My learned friend from Port of Spain South made reference to the case of Mandata Singh. 1988 existed before the 1994 Bail Act and before all of the different amendments made reference to Felicia Constantine. And he said, well, it wasn't overturned by later cases. It wasn't overturned because it wasn't even mentioned. It's OTOs. Nobody refers to that case anymore. Then there was a complaint about masters being overburdened. Well, if masters are overburdened, you proclaimed a JIPA. You had enough time to fix it. You had enough time to employ enough masters, to employ enough staff, and you didn't. So what is the big song and dance about? But the one guarantee we'll give you, not that Philip would fix it, but we would fix it. Just as today, we are fixing the mess that you caused in the courts by your ineptitude, 8 lawyers on that side, ineptitude when you passed the 2024 Bail Amendment Act. Let me see. Well, there seemed to be an admission from that side that magistracy registrars and clerks of the peace are already engaging in this exercise, which is not, we are not giving them that much more power. What we are giving them is a statutory license to do what the law does not allow, what they do in practice, but what the law does not allow, particularly magistrates who are creatures of statute and cannot embark on this sort of procedure. But since you, well, I know it may have been hard to express it outwardly. It would have been hard to, but it's quite clear from your language that you have, from your subliminal vibrations, that you've conceded defeat. That you have no point. Oh, just wrap up quick.
You heard to what, Brian? You can't take it.
Oh, God. Well, again, in a failed attempt to say, well, it breaches the right to privacy, this bail source hearing, my learned friend probably did not read the bill. Because if you read the bill, you would see that the right to privacy is preserved. Because the hearings can take place in camera. Isn't that the whole point in camera proceedings to protect privacy? So again, what really is the complaint? The complaint is that you had 10 years to do it and couldn't do it, and now you're vexed that somebody has done it. But you're going to learn to put that in your pipe and smoke it. You're going to learn. Sorry, I hear my friend in the back here. You're going to learn. In my Tobago accent. Yeah, I know it's hot in here. Well, Mr. Speaker, you see what, and when I answer them, all you just get vexed. I don't know where's the fascination with the jockey shorts.
I love it.
You're fruity, you're fruity. You're fruity. You need to come out and say that you've embraced the love that dare not speak its name.
Randy, please address me.
Coming to the close, I have to make a complaint so that the public looking on can understand what is taking place, not just here, not just in the lower house, because in the last few debates, the other side, and not the 6th or the 7th, but the 8th, they have demonstrated a level of wokeness that I've never seen. Imagine you are in a parliament where you have who we would think would be right-thinking persons making excuses for criminals. They could envision, they could drum up, they could use their imaginations to conjure up all sorts of factual scenarios to say why the legislative provisions that we are bringing would not work. Thank you, Mr. Speaker. Oh, God.
Quick, 1 minute, 1 minute.
In the 1 minute I have, Mr. Oh, I have extra time? Yes, please.
You can get your 15 minutes.
Yes, please. I would like to avail myself of it. Not much of it. Just enough to rub it in a little more. Yes. I am concerned of the level of wokeness and how they could easily conjure up all sorts of arguments as to why legislation which targets the criminal element ought not to be passed. I thought we were gathered here, all of us, to protect the law-abiding from the most dangerous elements who have to be faced with draconian bail of high amounts. But it seems as though we on this side are trying to protect the law-abiding, whilst they on that side are seeking to protect the lawbreakers. That is an unfortunate state of affairs. But I'll deal with you just now. Yes. I'll deal with you just now. Yes. So, Mr. Speaker, as I indicated, I'm not going to use much more because I was hoping my friend from Laventille West would come back so I could put some more licks on him, but he's not. So let me just wrap up quickly and say that, and we are saying it now, that during committee stage we propose to amend the bill in terms of the written amendment that is, has been circulated. And in the margin, there's just a slight change. It says 3 in the margin. That 3 should actually be 2. So 3 is a typo. So, Mr. Speaker, with those few words, not yet. With those few words, I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Bail Act, Chapter 4, 60 be now read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
A bill entitled An Act to Amend the Bail Act, Chapter 460.
Leader of Government Business.
Thank you kindly, Mr. Speaker. Mr. Speaker, in accordance with Standing Order 15.5, I beg to move that the House continue to sit until the completion of the business before it.
Members, the question is that the House continue to sit until the completion of the business before it. Those in favour say aye. Aye. Any against? The ayes have it. Minister of Defence.
Speaker, in accordance with Standing Order 68.1, I beg to move that the Bail Amendment Bill 2026 be committed to the Committee of the Whole to be considered clause by clause.
Honourable members, the question is that the Bail Amendment Bill 2026 be committed to the Committee of the Whole to be considered clause by clause. Those in favour say aye. Aye. Those against say no. The ayes have it. This House shall now go into the Committee of the Whole to consider the bill clause by clause.
clause 1.
The question is that clause 1 stand part of the bill.
Chair, we propose to amend in terms of the written amendments which have been circulated.
Mr. Chairman, we are supposed to be circulated with amendments. We have not been circulated.
No, I am advised that it was circulated via email as well as printed copy.
No, but an email, we would not know this, Mr. Chairman. The practice is a written piece of paper. How would we know amendments are circulated unless we are told go and check the rotunda or something like that?
Well, I am advised that the practice by the clerk, that they have satisfied the practice that it was circulated by email and also
No, sir.
the chief
No,
whip
sir.
was it.
In my 34 years here, I say that is not so.
I am advised that copies were given to the chief whip.
Well, he's not the only member here, sir. He's not the only member. You're all just ridiculous.
Let's move on, shall we? It's a relatively simple amendment. All right. I propose to put the question. The question is that clause 1 be amended as circulated. Those in favor say aye.
What it is.
Aye.
All right, Barataria, is either aye or no. Those against say no. The ayes have it. The honourable members, the question is that clause 1 as amended now stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 1 as amended now stands part of the bill.
Clause 2.
Chair.
Yes. The question is that clause 2 stand part of the bill.
Chair, there's an amendment. It has been circulated. To the best of my ability, I am not able to jump like a jackrabbit into the members'
As insulting as you want. I am making a serious point.
Chairman.
The amendments were not circulated.
All right.
And
Okay.
Mr. Chairman, the Attorney General is prone to throwing insults across the House.
Well, I guess that makes both of you. I guess that makes both of you. So let us not
throw insults,
let us not decide who's more proficient at trading barbs and
Chairman,
insults.
I object. I do not throw insults like him. I don't call him a jackrabbit. I don't call him a frog hopper. That's what he does over here.
All right. I don't intend to put up with this tonight. If I were to invoke the words of Owen Reyes Johnson in his seminal song, that ain't working here tonight. All right, so let's move on. The question is that clause 2 be amended as circulated. Those in favor say aye. Aye. Those against say no.
No. Hello, wait.
I did not see you. Okay.
Thank you very much. Mr. Chair, it appears to us that the proposed amendment is to delete the need for a special majority of Parliament. Mr. Chair, it is our position on this side that it requires the 3/5 majority as was originally inserted. And the reason for that, Mr. Chair, is what you're doing here is you are affecting the fundamental rights of persons, but also the separation of powers argument is that what you're now telling the court is that once there is cash in the sum of $30,000 or more or a certified copy of a deed, they are now confined to having a mandatory bail source hearing. So, Mr. Speaker, it is our position, and maybe the reason for this deletion after it came to the House, in a format where originally the bill had the requirement of a special majority is what happened earlier this week in the Senate.
Whether that is, whatever might have motivated that, really, I don't
But
think
it's our position, it should stay.
It doesn't form part of these discussions. Honorable Attorney General, would you wish to respond to that?
Absolutely not, Chair. The amendment has been circulated.
All right. So I propose now, after giving the right to be heard, to put the question. Members, the question is that clause 2, that as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 2 as amended now stands part of the bill.
Clauses 3 to 5.
The question is that clauses 3 to 5 stand part of the bill. The question is that clauses 3 to 5 now stand part of the bill. Those in favor say aye.
Mr. Chairman, I had my hands up. Here. Just to ask if I may please, Mr. Chairman, in clause 5, which seeks to amend section 5, subsection A, it reads in subsection 2 by deleting the words and subsection 6, and it continues without a close quotation until the end. It might just be a typographical, but it may make, just to bring it to the Honorable Attorney General attention, that after and 6, that it should include a close quotation mark.
I'm told that the printed version on the Parliament website has it corrected. In any event, we all know that there's a law revision commission, not a law reform commission, which deals with typographical matters.
Okay.
Thank you.
Mr. Chairman.
The question.
I'm not finished yet, please. It's from clauses 3 to 5 or 3 to 6? 3 to 5 is on.
There being no amendments, no proposed amendments to those clauses, the rules entitle us to take them together.
Deeply grateful, please, Mr. Chairman.
Right. So can I put the question now? Right. Thank you. The question is that clauses 3 to 5 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clauses 3 to 5 now stand part of the bill.
Clause 6.
Clause 6 now stand part of the bill.
Mrs.
For the Spain South?
Mr. Chairman, I would start with clause 6, 2H. I've circulated a written amendment where I have proposed that we change where the court, having completed a bail source hearing, is satisfied that the source of cash or real property used by the accused or the surety to secure bail was derived from illegitimate means, to an amendment where the prosecution establishes the proposed surety is unsuitable to secure the attendance of the accused. I think that that proposed amendment will restore the bail and the process and purpose of bail to its proper purpose of securing the attendance of the accused, rather than permitting detention based on suspicion about source of cash or real property. And that is the rationale for my suggested amendment.
Mr. Speaker, Mr. Chairman, sorry, this is mere surplusage because what is being proposed in each is already existing law. So what we are dealing with now is a bail source hearing and what the court can do in the hearing. So quite apart from that, the court, looking at the statutory declaration, particularly in the second schedule, would make its own determination outside of the bail source hearing to determine whether the proposed surety is able or not able to secure the attendance of the accused. So that's not necessary in this bill. The amendment takes us nowhere.
Chair, I will not engage in fact, I don't actually think I want to engage in even a conversation with that member, but my proposal,
all of that is not necessary.
I am very, very serious. My proposal, however, is not as the law is. It is this amendment as it is, and I'm really talking to the Honourable Attorney General respectfully through you, Chairman. It places an onus and of emphasis on denying bail if it is the accused or if it is shown that the source of the real property or cash was derived from illegitimate means. What we are saying here is it now places the burden, and it is in keeping with the rationale of bail, where the prosecution establishes that a surety is unsuitable to secure the attendance. It refocuses, I think, the emphasis on the attendance of the accused, and that is why I'm proposing it respectfully.
Honourable Attorney General, you wish to respond?
Thank you.
Just to say that the government does not agree. We think that this is a core court function and that the position is properly stated by us and not by the member. We disagree.
Okay. I propose to put the question unless there are any other comments. Right. The question is that clause 6, right? 6. That clause 6 now stand part of the bill. Those in favor say aye. Those against say no. The ayes have it. Clause 6 now stands part of the bill.
Chairman, my circulated proposed amendment refers not just to 6.2, but 6b and 6c. I've circulated the written proposal. We have not moved on from there, have we, Chairman?
I think we haven't gotten there yet. I
you.
think those amendments in your proposed proposed amendments refer to clause 7 and 9.
Yes, please.
All right. So I don't think we've gotten there yet.
Yes, please.
I think the clerks are conferring to give some advice. Members, I want to go over this. I'm advised for completeness of procedure. All right, that we need to put the proposed amendments to a vote. Right, and so I propose to do that. All right, so what I propose to do is put the question over and then put back the original question. So what I propose to do is put the question that clause 6 be amended in terms of the proposed circulated amendments. Those in favor say aye. Aye. Those against say no. No. Right, I think we agree the noes have it, right? I now propose to put. Right. The question is that clause 6 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 6 now stands part of the bill. My apologies for that sort of protracted procedure, but I am advised by the clerks that for clarity of the public record, it's necessary.
Clause 7.
Question is that clause 7 now stand part of the bill. Honorable Attorney General.
We propose that the clause be amended in terms of the list that I have circulated, which members of opposite seem to have found. I don't expect an apology.
Mr. Chairman, I would be grateful if the member for the other side and the other place would keep my name out of his.
Okay. Let's not degenerate a fruitful discussion.
Me. I didn't say anything. Why are you doing that? Look at him. Don't look at me.
I'm looking at all of you. It's rather late for that. Okay. Huh? Huh? Mm-hmm. The question is that clause 7 be amended as per the proposed circulated amendments. Those in favor say aye. Well, come on, man. All right, I am advised that we must invite the member for Port of Spain South who has circulated some amendments, and then I will put it to the vote. Member for Port of Spain South.
Mr. Chairman, I've circulated and I would like to take them both together with relative to clause 7. And we are proposing on this side an amendment to 6B1, 2, 3, and 4, and 6C1, 2, and 3 in terms of what I have circulated in writing. Mr. Chairman, the justification of this is that by these amendments, it removes a mechanism that will delay the release and reverse the presumption of innocence by converting a bail hearing into a financial investigation. We are of the opinion, for example, that to the requirement of the burden to prove that the real property or cash was derived from legitimate means, and the proffering of the cash and the using of the property to secure bail is an inquiry that is intrusive. It will take time, Mr. Chairman, and it will, in circumstances, respectfully, must require cross-examination. Anyone with any iota of common sense and any practice history in the courts will know, unless a court takes he lie, she lie, the test must be the crucible of cross-examination. That is really a trial within a trial. It's a voir dire, and a rose by any other name remains a rose, and that will delay the release of persons not even charged with serious offenses. And in the circumstances, I am proposing the full amendments that are contained here. I don't wish to go through them in seriatim. I will take them omnibus.
Minister of Defense.
Mr. Chairman, 6B1 is already standard procedure. 6B3, with respect to the statutory declaration in the prescribed form, is already done in relation to the second schedule. And 6B4 seeks to undermine the various provisions of the bill. So we are not minded to agree.
Would you want to address the proposed amendments to 6C1, 2, and 3? as well, so for completeness?
Yes, please. Mr. Chairman, that amendment is misconceived. There already exists a court investment fund where monies are deposited into, and what is stated in 6C2, all of this already exists as part of the process when one goes to have the money deposited into this fund I just stated, the court investment fund.
Okay, great. There being no other proposed comments on the proposed amendments, I propose to put the question. Honourable members, the question is that clause 7 be amended in terms of the proposed amendments as circulated by the member for Port of Spain South now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. All right, I think the noes overwhelmingly have it. So the resolution of that question is that clause 7, the proposed amendment, the amendments proposed by the member for Port of Spain South to clause 7 do not form part of the bill. I now propose to put the amendment by the Honourable Attorney General. The question is that clause 7 be amended as in the terms as circulated. Those in favour say aye. By the Honourable Attorney General, yes. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable members, the question is that clause 7, as amended in terms proposed by the Attorney General, now stand part of the bill. Those in favour say aye. Aye. Those against say no. Clause 7, as amended in the terms proposed by the Honourable Attorney General, now stands part of the bill.
Clause 8.
There are no amendments. That clause 8 stand part of the bill.
Proposed by the Honourable Attorney General to clause 8, if I'm not mistaken. No, I'm sorry. No, sorry. That's a good original. I apologize, sir.
Okay. The question is that clause 8 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 8 now stands part of the bill.
Clause 9.
That clause 9 stand part of the bill. Port of Spain South, you have a proposed amendment which you've circulated.
The jurat as it is and the declaration, on this side we have the respectful opinion that it should have the clause inserted to the best of my knowledge and belief, which puts it gives a buffer to a situation which may very well be unsavory for the person making the declaration, and it gives a sort of, in our respectful view, it softens all that has gone before, and it protects the declarant or the affiant in the circumstances of this. So through you, I would ask the Honourable Attorney General to consider that amendment and at least insert the phrase "to the best of my knowledge and belief."
Of Defence or Honourable Attorney General, whichever of you.
Mr. Chairman, if one looks at the statutory declaration that is part of the second schedule, there already exists a declaration, the standard declarations under the Statutory Declarations Act. So to agree to that amendment, in essence, it's an exercise in superfluity, redundant. Yeah, well, you learn something. It's superfluous.
Okay, I take it there are no more proposed comments.
Well, no, Mr. Chairman. It's a waste. I say no.
All right, I propose to put the question, unless there's an objection to me doing so. The question is that clause 9 be amended in the terms as circulated by the member for Port of Spain South. Those in favor say aye. Aye. Those against say no. No. The noes have it. Honourable member. The question is that clause 9 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 9 now stands part of the bill.
Preamble.
The question that the preamble to the bill be not approved. Those in favor say aye. Aye. Those against say no. The ayes have it. The preamble to the bill is not approved. Honourable members, the question is that the bill as amended be now reported to the House. Those in favor say aye. Aye. Those against say no.
Sorry. There's a parliamentary certificate.
The clerk has advised that that's a consequential amendment that is automatically deleted.
Sure.
I did inquire about that and was told before. All right, so the question that we have put is that the bill as amended be now reported to the House. Those in favor say aye. Aye. Those against say no. The ayes have it. The bill as amended will now be reported to the House. I could go with this, right?
Mr. Speaker, I wish to report that the Bail Amendment Bill 2026 was considered in the Committee of the Whole and approved with amendments. I now beg to move that the House do agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Bail Amendment Bill 2026. Those in favour say aye. Aye. Those against say no. The ayes have it. Minister of Defence.
Mr. Speaker, I beg to move that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a third time and passed. Say aye. Aye. Any against? No. The ayes have it.
To amend the Bail Act, Chapter 460.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that this House do now adjourn to a date to be fixed.
The question is that this House do now adjourn to a date to be fixed. Those in favour say aye. Aye. Any against? This House now stands adjourned to a date to be fixed. Thank you very much and good night.
Very much, Mr. Speaker. Mr. Speaker, to the Minister of Homeland Security. In light of the January 20th shooting in St. Augustine, where CCTV footage appears to show Joshua Samaru surrendering, could the Minister state what immediate steps are being taken to ensure a full and transparent investigation?
Minister of Homeland Security.
Mr. Speaker, those on the other side profess to be very bright. However, let me say this. This is a very...
Well, just answer the question.
Mr. Speaker, this is an ongoing investigation by law enforcement. As a result of that, Mr. Speaker, SO 27-1G.
Mr. Speaker, the Minister indicated, and the question to the Minister, that having regard to the fact that he confirmed that an investigation has started, the question to the Minister is what promise, what undertaking his office is being given to ensure a full and transparent investigation into this very important matter. You cannot, Mr. Speaker, because he's raising...
Don't require speech. All right. Calm down, everyone. I do not require speech. You are very well aware that these standing orders permit questions. They do not permit a speech. Ask a question. I'm not going to treat that as a first question. So if you're prepared to ask a question in conformity with the standing orders, I'm prepared to allow it. But ask a question. I'm not prepared to entertain a speech.
Thank you very much, Mr. Speaker. To the Minister. Minister, having regard to the fact that you have attempted to raise Standing Order 27-1 to not account to the people of Trinidad and Tobago on your ministerial responsibility, are you...
All right. I have repeatedly elucidated the operation of Standing Order 27-1G. Okay? As I have said, and I don't wish to repeat what I previously said on how public interest immunity works. Remember, Faruqa Lupino, you've been a lawyer for over 15 years now. Surely you must be familiar with the principle of public interest immunity. Once public interest immunity is invoked, I don't have the mechanism, neither do I have the jurisdiction to undertake an examination or a second guessing of the invocation of the public interest immunity rule. That is what 27-1G is. And it's not an isolated mention of the public interest in these standing orders. It is interspersed repeatedly throughout these standing orders. So it must mean that the Parliament as a collective body of legislators took the informed decision to give to the relevant minister the power to claim immunity from answering questions. Now, as you are well aware, the public interest immunity is not a principle which is fixed in stone. Rather, it is a protean concept. It is capable of taking on many forms. Okay? That's what it means. I don't have the jurisdiction or the power to second guess or examine, and I've repeatedly explained to you, if I was sitting as a judge in a common law court, I had the power at common law to tell the minister, bring that information, let me see it. And I will determine. You know why? There's a legitimate public reason for that, because it would undermine the fairness of the trial. We don't have that here. So hold on. Right? Yeah, I am as well. So if you would not engage in this tiresome malarkey repeatedly, we would move along finely. So you have one more question you've asked. So one more supplemental. Oh, so we move on to the next one. Number 5, Member for Aruka Lopino.
Thank you very much, Mr. Speaker. To the Minister of Homeland Security, in light of the January 20th shooting in St. Augustine, where CCTV footage appears to show Joshua Samaru surrendering, could the minister state what assistance is being provided to the immediate family of the victims?
Minister of Homeland Security.
Mr. Speaker, this matter is under investigation at this time. It's one of the most intense investigations that is steering the police attention at this time. As a result of that, I invoke SO 27-1G.
Yes, all that, yes.
Mr. Speaker, the member is responding to my question and in the middle of it invoking standing orders 27-1G not to respond. So he has to take a position. Is he going to answer the question, or is he going to invoke the standing orders not to answer the question in accordance with public interest?
All right. Having said that, the sum total of what the minister said is the invocation of 27-1G. It serves no useful purpose to determine whether or not he took a run-up or he chipped along. It's carnival season, I know we could say he chipped along to it, but ultimately the decision is the minister's invoke 27-1G. All right.
Finally, Trinidad and Tobago, the PNM suddenly know or could call and say with their mouth, teachers, because for 10 years they said nothing, they could have done nothing, they did nothing for the teaching fraternity and particularly for teachers. But now, given that they are in opposition, they have a lot to say. This is Nyan Gaspidoli, former Minister of Education.
So for those who are not sure what's happening, teachers have been promised back pay and a raise of pay. Since April the 18th, 2025, and I would have been the minister at that time, TUTA and the CPO reached an agreement for a 5% increase. And so teachers were within their right to expect that before December 2025, you know what happened in the intervening period? The government changed, the minister changed, and of course, one would expect that, you know, there would be processes that would have to be gone through. And one would have thought that it would have happened before Christmas of 2025 or December 2025. As the old people say, teachers were waiting, back pay, nothing. You know what the old people pulled their eyes so? They didn't get anything. So the PSA agreement, if we want to contrast, since April 18, 2025, TUTA and the CPO had come to that agreement. The PSA came to an agreement in November of 2025, late November, it was about the 27th of November or so. And the PSA members got a partial back pay in December of 2025. So if you want to put that in context as to why the teachers feel disrespected, it is because their agreement was made so many months before. But what is the difference between TUTA and the PSA? We saw the PSA president on the UNC platform during the general election campaign. So what is the clear connection? It is clear then that the payment of back pay and increase in pay had a political input. And that is extremely unfortunate and disrespectful to the teachers whose agreement came many months before. So the PSA president...
I'll stop it there. That full misinformation is on YouTube for you to see under the title PNM Lies. All right? But let me bring the facts to you now, Trinidad and Tobago. The fact is that the PSA workers, they're not waiting since November 2025. They've been waiting for 10 years now, just as the teachers have been waiting for 10 years now. When you want to talk disrespect and they don't like this and they don't like that, or the teachers are feeling disrespected, 100% true, the teachers do feel disrespected, but it's based off built up frustration for the past decade, not just under PNM alone, but for the past decade. The fact is though, the only administration that ever